Welcome back. We're now on air again, and we now resume our proceedings and welcome representatives from the Queensland Human Rights Commission. I will now introduce Mr. Scott McDonald, the Human Rights Commissioner. Good morning, and thank you for joining us today. I would like to invite you to make an opening statement, after which the committee members will have some questions for you.
To ensure that a strong human rights culture is maintained, it is open to a committee to identify when a minister's statement of compatibility requires further justification for any limitations on human rights proposed in a bill. This might occur, for example, when the statement of compatibility does not adequately address the less restrictive options available to achieve the purposes of the bill. In our submission, we respectfully suggest that several aspects of the bill require further justification. While the departmental response is helpful in gaining further understanding of the nature and the purpose of the human rights limitations, we suggest further justification should be sought. For almost 18 months now, COVID-19 has placed immense pressure on various parts of our society, including our democratic system. It is of fundamental importance to our democracy that we do not allow what could be described as compatibility fatigue to breed a level of complacency with respect to upholding foundational liberties and freedoms and fundamental legislative principles. The immediate urgency of the pandemic may have justified the extraordinary powers in the suite of COVID legislation that has been passed to date. With the advent of vaccines, however, we should be able to identify the measures required to move beyond the state of emergency and the laws that are needed to implement those measures. Whilst it is no doubt expedient for Parliament to delegate legislative power to facilitate swift responses to emerging developments, and I take the Chair's comments about the recent developments of the Delta strain, there are some measures that clearly warrant the scrutiny and the authority of the Parliament and should be enshrined in primary legislation. A good example of such a measure is the recent decision of the Chief Health Officer to mandate vaccinations for health service employees, QAS employees and contractors working in COVID-19 wards. We suggest further justification is necessary to explain why such a significant power should be exercised without a clear parliamentary mandate. In light of the anticipated decision to extend the mandate to aged care workers, we submit that this power should be narrowly tailored in primary legislation, introduced, debated and scrutinised in the usual way. Such a process is likely to identify appropriate safeguards and protections and confirm that Parliament does indeed consider that the power should exist. Similarly, the modification framework may have been necessary at the outset of the pandemic to allow legislation to be quickly amended, but we suggest those amendments that remain necessary should now be made in the usual way through Parliament. The nature of the pandemic may mean that many restrictions continue to be made by public health directions. Nonetheless, we suggest the community would benefit if there was a requirement for the Chief Health Officer to publish her consideration of human rights, much like a statement of compatibility or a human rights certificate, within 3 to 5 days of the direction. Similarly, we have recommended that there should be a process for seeking a review of a direction to isolate, as has been introduced in Victoria, and at the very least, a requirement to provide a statement of reasons to individuals when exemption decisions are made. But above all else, it's critically important that the government continue to adequately justify each and every limitation on rights that arises from legislation such as this and demonstrate that public health measures remain the least restrictive, most reasonable and proportionate way of responding to the pandemic.